With that, Ms. Levy, would you please begin the announcements?
Sorry about that. Leslie Levy, attorney for the department.
Shelley Nix, belong permanency specialist.
Anna Swallow, attorney on item for the child. Ready?
Goldie Rabson, Hill Country CASA, guardian ad litem supervisor. Judy Hartnett, if you'll.
Judy Hartnett, CASA volunteer, guardian ad litem.
All right, we are here for our first permanency review after our final trial. Amari at this time is 1 and still living with the Valdezes in Kerr County. Ms. Coffey, is that placement safe and appropriate?
I
Meeting
haven't been
is
sworn in. I think that Shelley is going to testify.
okay. Ms. Nix, is Amari's placement safe and appropriate? Meeting his needs?
Yes, Your Honor. Miss Coffey is going to be the worker, and this is my last appearance for him, but I told her I'd be prepared to testify today. So,
okay. And permanency goal is relative adoption?
yes, it is.
And this is the least restricted placement available?
It is. It's the perfect placement available.
And no other family members have come forward since our last hearing?
No, they have not.
Amari's up to date on all of his checkups?
Yes.
Any special services at this time?
No, he seems to be developmentally on target. He was evaluated by ECI previously. We had a permanency conference last week and brought Miss Coffey up to speed. Amari's dealing with a few little chronic, I think I put a little paragraph in there, a few little chronic health issues ongoing, and he's set to see a couple of specialists, an ENT about tubes, maybe something to do with his tonsils, and then a gastroenterologist, just because he's got a lot of digestive issues going on. So
Okay. But all in all, everything's going well.
yes, very well.
And any obstacles to the permanency goal at this time?
The only barrier, Your Honor, and I'm just going to call that a temporary delay, is the verification for adoption through SJRC, which Mr. and Ms. Valdez have been working on for some time. Ms. Coffey is also the assigned worker for Amari's sibling, and they're closing in on it. So as soon as they're able to complete the process with SJRC, they'll be verified and approved for adoption, and then that barrier will be gone.
Okay. Any specific reasonable efforts that Belong has made towards achieving the permanency goal?
I think mainly just trying to help Mr. and Ms. Valdez find a CPA that would carry him across the finish line. I know that through unforeseen difficulties, they were not able to be licensed by the first agency they contacted. The second agency started with them and then went out of business, and then they were referred to SJRC. So I think we've done everything we can to assist them in this, and it's just been delayed through unforeseen circumstances.
Okay. All right, Ms. Levy, do you have any questions for Ms. Nix?
I don't, Your Honor.
Ms. Swallow?
Thank you, Judge. Ms. Nix, do you know whether or not it would be prudent at this time to go ahead and request the HESIG and redacted file?
That actually already has been requested in anticipation of this, and we kind of piggybacked off of the other HESIG and case redaction, so it was added to that.
Okay. You're referring to the companion case?
Yes.
Okay. And as far as Amari's health, he has some things going on, does he not?
Yes, he does.
And could you just briefly explain to the court what's happening with him?
He has had ongoing ear infections since he was placed with Mr. and Ms. Valdez, after back-to-back ear infections and a lengthy time on antibiotics. He developed a case of C. diff, which my understanding is that can be a side effect of being on antibiotics for a long time. That essentially messed up his internal digestive system, and now it's difficult for him to take antibiotics. So they have been referred to an ENT to resolve the chronic ear infections by placing tubes, which will hopefully alleviate that problem altogether. And then Ms. Valdez reported that he's going to be taken to a gastroenterologist just to be sure that there's nothing going on beyond the inability to tolerate the antibiotics any longer.
Okay, and So when he's sick, he can't take antibiotics, correct?
He should not, no, because of the previous tendency to develop the C. diff.
Okay, and that's been difficult, has it not?
I mean, it's hard to fight an ear infection without antibiotics, and that's why they're going to the ENT.
Okay, and the potential prognosis would be if we do not address this, he could end up with some sort of bag, correct? Like if this is a pretty serious issue.
Oh, for the gastrointestinal,
Yes.
I don't know if there's any potential side effects like that. That was not brought to my attention.
Okay, okay, thank you, Ms. Nix. I pass the witness.
Any other witnesses, Ms. Levy?
No, Your Honor, state would rest.
Anything else from you, Ms. Waller, besides a report?
Just a report, Judge.
Go ahead.
So I have serious concerns regarding what Amari is going through. This is a pretty big deal. He can't drink, he's over a year old. He can't drink cow's milk. He still has to be on formula. He can't have lactose free either because it messes with his stomach and gives him explosive diarrhea. And when he has this type of diarrhea, because he has C. diff, I mean, it has to be a very sterile situation because it's highly contagious. So, and he can't take regular medicines when he's sick. And, this appointment needs, I think it's on June 5th. And my hope is that, we can assist this family or at least be there as a support to this family while they're going through this. This isn't a normal basic needs issue for a child. His brother did absolutely have to have the tubes and the surgery, but Amari's immune system is pretty stripped out. He doesn't have any good or bad bacteria. So we've got to figure out how to rebuild that for him.
All right. Do you have any proposed or any requests or proposed relief as far as getting in there and figuring out what's going on besides what they're doing already?
I think the placement is doing the best they can. I wouldn't say ordering belong to make sure this happens is necessary because the Valdezes are extremely dedicated to Amari and figuring this out. I think it's just important that it be on everyone's radar. And if in fact we do need some other type of referral or a specific court order, I may be touching back with the court after his appointment on June 5th.
Okay. Understood.
Thank you.
You're welcome. Thank you. Casa, Ms. Hartnett?
I agree with everything that's said. I would also add that he has had tonsil problems too. And I believe that they're seeing the ENT today. So maybe they'll get some answers about the tubes and maybe what to do about the tonsils. The C. diff is a very serious issue. And placement has mentioned to me that if they don't get it taken care of, that there is a possibility he might have to be on a bag at some point in his life. So it is something that needs to be addressed as soon as possible. That said, placement is doing everything they can. And I agree that we just need to support them however we can.
Thank you, Ms. Hartnett. For the purposes of the permanency review after final order, the court finds that the permanency goal of relative adoption is in the best interest of Amari. Court finds that his placement with the Valdezes is safe, appropriate, meeting his needs, and in his best interest to continue. Court finds since our last hearing, no other family members have come forward. And I just know from being in this case throughout the whole thing that he's bonded to them. So placement's in his best interest. Court finds that he's up to date on all of his checkups and that he's not receiving any special services at this time. I'm a little concerned about the antibiotic digestive system connection we have going on, or disconnect really, that we have going on here. So I'm going to order all of you to staff that. Let's say it's May 15th. Let's say by June 1st or before. Just make sure everybody's on the same page. And I want the Valdezes to be part of that. I want everybody that's in this case to know what they deal with on a daily basis and to know what Amari deals with on a daily basis so that everybody's on the same page as far as if his treatment is enough. I'll find at this time that it's appropriate, but I want that staffing to make sure that we're not missing anything here.
Judge, may I?
Yes.
Can we have that staffing occur after his June 5th appointment? So to have the staffing occur by maybe June 14th or.
That'll be fine. I mean, I wanted to get it done as quick as possible, but I think if you feel like that information from that appointment is going to be pertinent to the meeting, then I think that's more appropriate. So let's say it's the 14th, right?
The 5th is the appointment, maybe the staffing by the 14th.
All right, let's say do the staffing by the 14th.
Thank you.
You're welcome. Thank you for the clarification. The court finds that the only permanency goal to the adoption, the only obstacle to the permanency goal at this time is the age verification through SJRC. I understand that with the previous issues with CPAs that, obviously that's created some delays for us. But I will find that Belong has made reasonable efforts in working with the Valdezes to help them get licensed, despite the fact that their previous agencies fell through. Our next hearing is going to be October 2nd, 2024 at 2 p.m. October 2nd, 2024 at 2 p.m. I think we would be well within our time limits for an adoption before that. So if we get this other part figured out, just let us know and we'll get it on the docket. All right. Thank you all for your time and your service. Ms. Valdez, thank you for what you and your family are doing. And if there's nothing further, all parties are excused.
Thank you.
Everybody.
With that, Ms.
Thank
Levy,
you.
would you please begin the announcements?
Leslie Levy, attorney for the department. Alejandra Sartuche, permanency specialist with Belong.
Ashley Crouch, Permanency Supervisor for Belong.
Anna Swallow, attorney ad litem for the respondent father, Caleb Miller. Mr. Miller, could you please unmute and state your name?
Caleb Miller.
Thank you.
Kathleen Savage, the attorney for the respondent mother, Carly Jenkins. Ms. Jenkins, will you state your name for the record?
Carly Jenkins.
Richard Sullivan, attorney for the child. Ready?
Goldie Rabson, Hill Country Casa, guardian ad litem supervisor. Miss Jewel, if you'll unmute and announce.
Sue Jewell, Hill Country Casa, guardian ad litem for the child.
We're here today for a progress hearing. I wanted to come back. We were here on April the 3rd, and I wanted to come back and see what sort of compliance the parents were in and what sort of progress they were making before we waited for another 2 or 3 months. And then also look into the hair test. Ms. Zartuche, I did read your report. Just for the record, I'm going to ask you a few questions. You can give me a brief rundown on what's happened since we were last here. Let's start with Ms. Jenkins. Your report reflects that she's in compliance.
Yes.
All right. And it looks like she might have missed a visit, but otherwise she's been attending pretty regularly.
Yes, she's been consistent with her attendance for those visits.
Okay. And she's engaged in her classes.
Yes, so far, yes.
Okay. Kept her camera on during the visits, during the video calls.
Yes.
Okay. Have you tested her recently?
She was tested in Virginia. I was able to find a provider in Virginia to complete a mobile testing, so they went to her. And they took the samples, but they had a situation at their facility where their machines were down for a whole week. So it put them very behind, and I haven't received those results yet. I checked in on that last week and this morning, and I haven't gotten a response yet.
Okay. So is it your testimony to the court that she's been cooperating with you and that she's making good progress at this point?
Yes, we're in constant communication throughout the week.
Good. All right. Good job, Ms. Jenkins. All right, let's talk about Mr. Miller. Your report reflects that kind of the opposite, that he's not fully in compliance and that you've been having some troubles communicating with him.
Yeah, at the time that I filed the report, he wasn't being consistent with communication. It was like off and on. And then he came back to Kerrville, and I got him set up with local providers for services. Although the psychological and his individual counseling was already the same ones, so he had that information. And then he had to reschedule his psychological because I think the day he was coming to Texas was the same day it was scheduled for, on the 19th. So he originally missed it, but he quickly rescheduled it for the 23rd, and he did complete that. And then he had a visit with Jordan the following week. So he got here on a Friday. So the following week on Thursday, he had a visit with Jordan. And after that, for those next 2 weeks, he wasn't being so responsive anymore, so he missed the next weeks after that one for visits with Jordan. And as of yesterday, he has gotten set up with his individual counselor, and I was able to take him to complete a hair follicle test in Bernie, and he is scheduled for an OSAR assessment as well. And the only thing left is his parenting classes. He hasn't been able to go do that. Oh, I'm sorry, and the domestic violence classes as well. That was kind of a long process. They kept going back and forth with me for a different paperwork and document that they needed. And they finally reached out to both parents yesterday, and both parents responded with the documentation they needed. So they're just waiting to hear back to get scheduled.
So would you say, as of now, Mr. Miller is cooperating with you and he's in compliance?
As of today, yes.
And is he, you had mentioned some things in your report regarding being unresponsive or disrespectful. How is his attitude towards you now?
I think his attitude is pretty I mean, it's not like my other a lax conversation where he's very comfortable to use some certain language that I feel is inappropriate. So, but other than that, it's fine.
Okay. So all in all, based on where we were on April 3rd to where we are today, it sounds like from your testimony, we've made some significant headway.
Yes, just this week alone.
All right. Ms. Levy, do you have any questions for Ms. Artuche?
No, Your Honor, I don't.
Ms. Savage?
Yes, Mr. Tucci, you've been made aware of some aggressive statements and behaviors from Mr. Miller to Ms. Jenkins, is that correct?
That's correct.
Because the parents at this time are no longer in a relationship?
Correct.
Do you believe, given the aggressive nature of several of those texts and communications, it would be appropriate for the court to order a no contact order between the parents?
I'm sorry, it cut out. It cut out after you said, do you believe?
Do you believe that given the aggressive nature of some of these communications from Mr. Miller to Ms. Jenkins, it would be appropriate for the court to order a no contact order between the parents?
I think that's appropriate.
Okay, and if these behaviors continue, will Belong be recommending Mr. Miller to engage in anger management or some other service to address his outbursts?
Yes, and I believe in his psychological, it did mention recommendations for anger management.
Okay, is that a service you've been able to refer him out to? Are you still working on that?
Usually with anger management, we have them address that with their individual therapist, but I can see if there's a separate provider to do that.
In regards to placement, is Belong still trying to look for fictive kin or relative placement for Jordan?
Yes, we were given the information for another individual, but she did not pass the background check for that. So, but we're open to any other relatives.
And Ms. Jenkins at this time is at least set up with every service requested from Belong?
She's set up with every single service, yes.
Okay, and as you stated, she's been in constant communication with you?
Yes.
I'll pass the witness, Your Honor.
Mr. Saldivar?
Judge.
I'm sorry, Ms. Swallow. I jumped ahead.
Thank you, Judge. Mr. Tucci, do you know the name of the individual that did not pass background?
Not at the top of my head.
Okay, was this someone in Virginia?
Yes.
Was it the initial person that was provided?
No, that's not the same person.
Okay, what's the status of that individual?
I spoke with the worker in Virginia that was completing the home study, and she told me that she was informed by her ICPC that it was going to be denied at this time, But as far as the ICPC and state office here in Texas, we haven't received that official notice from Virginia. So we're just waiting on that.
Okay, so when did you find that out?
I believe this was Monday.
Okay, could you please forward to the parties whatever information you have stating that home study is denied and why?
Yes, like I said, we haven't received the official notice. So once I do that, or once I get that from our state office, I will send that out. I just didn't want to send out word that I got from Virginia because it wasn't like officially received by us.
Okay, can you share the contact information of who you're dealing with in Virginia?
I can.
And have you forwarded to me Mr. Miller's psychological eval?
Yes,
And all of mom's services are virtual, correct?
correct.
So everything she's doing for this case is virtual, her visits, her services, everything.
Yes.
Okay. Is that a concern that she's not able to bond with the baby in person?
Well, yes. I mean,
Okay.
generally you would like a parent to be able to do that in person.
In regards to my client, he is presumed, correct?
Correct.
Okay, he's the presumed father. Are he and the mother married?
No,
Were they ever married?
not to my knowledge.
Okay, so he's presumed because he was on the birth certificate.
Yes.
If there are questions as to whether or not he's really the father, do you think DNA would be prudent at this point?
I think that would be beneficial, yes.
Okay. Okay, thank you. I pass the witness.
Mr. Saldivar?
Yes. Have you seen these text messages between the father and the mother?
I have.
Is it violent in nature?
Yes.
Does that cause you concerns with Mr. Miller's behavior and visitation with the child?
It does.
And why does that cause that?
The first visit I actually observed between Caleb and Jordan, Jordan was immediately upset, and he was just completely inconsolable. I think the visit lasted not even 10 minutes because he was automatically uncomfortable with Dad. But the time it got worse was when he was putting him on the changing table.
Okay. Now, are you asking, after that visit, has Dad attended any other visits?
He has not.
How many has he missed since that visit?
2.
And are you asking that this court order that he at least advise the department at least 48 hours before the visit that he's going to attend, and if not, to cancel the visit?
I would make that an order, yes. We have been doing it where the case aide will text him the day before or the day of, and he was not being responsive.
Okay. And you would like that as a court order, is that correct?
Correct.
Okay. And as far as behaviors during the visitation, or if the child's uncomfortable, are you asking that the court order that whoever's supervising the visit be allowed to stop the visit if it's not in the best interest of Jordan?
Yes.
Okay. And as far as the perpetrator to the abuse that Jordan was subjected to that brought this case in front of this court, has either parent admitted or identified who abused this child?
Not fully, no.
Okay. So the parents are still unable to describe to this court or to the department how this child sustained these injuries. Is that correct?
Correct.
Have they addressed that in any of their services?
I don't believe yet because it's still early on.
Okay. And is that concerning to the department at this point?
Yes.
Okay. And have there been any concerning photos that you've seen of Mr. Miller?
Yes.
And what are those?
It was a photo of him with friends where he was holding a gun.
Okay. And to this point, Mr. Miller hasn't addressed any of the domestic violence issues. He's been violent with mom, and now we're seeing him with pictures of firearms. Is that correct?
Correct.
Does that cause major concerns for the safety of Jordan at this time?
Yes. I think all around safety.
Okay. Now the visits in person, is Jordan having to be transported to see Mr. Miller?
Yes. Foster mom transported him to Kerrville the first time.
Okay. Is there any availability to have the father travel to the child if visitation occurs?
Yes, I believe we can make that happen.
Okay. Would you be asking this court that if any future visits happen, that Mr. Miller traveled to the child instead of the child traveling to him?
Yes.
Okay. Pass the witness, Judge. Oh, I'm sorry. I'm sorry, Judge. I have a few more questions. Are both parents working at this time?
Ms. Jenkins is working. Mr. Miller informed me yesterday that he has an interview today.
Okay. And would you think it'd be beneficial for the parents to pay child support to show this court that they can support this child?
Yes.
Pass the witness, Judge.
Any follow-up?
Yes, Judge. I don't know if I'm the only one.
No, you're up.
Thank you. The concerning photos you're talking about of my client, have you sent those to me?
I'm sorry, it froze. I didn't hear your question.
Sorry, the concerning photos that you just testified to that Mr. Saldivar was asking you about, have you sent those to me?
No, I have not. I received those and asked the client to defer to her attorney.
Okay. In the future, if you receive anything like that regarding my client, will you please send to me?
Yes.
And in regards to communications regarding my client, will you cease and refrain from discussing anything about his progress or lack thereof with the mother or her attorney?
Yes.
And as far as the transportation of the child, so you're requesting that this court modify its temporary orders wherein it was ordered that Jordan would travel to the parent in Kerrville?
Correct. I would want to modify that.
Okay. And will Belong be able to offer transportation to my client to be able to go to the child in Bernie?
Yes, we can.
Okay. Is that not where the child is in Bernie?
Yes, he's in Bernie.
Okay. And as of right now, my client has to confirm his visits 24 hours in advance. Now you're requesting, based on the ad litem's questioning, that it be 48 hours in advance?
I think any window would do. I think our case aide was doing it periodically to try to get him to confirm the visit.
Okay. So 24 is sufficient. Would you not agree with me?
Yes, I've done that with other clients.
Okay. And isn't it policy anyways that if the visit is not in the child's best interest, that it be stopped?
Yes.
Okay. And if this last visit, my client was ready to stop the visit. You did not, no one had to come in there and forcefully make him do anything. He wasn't being forceful with the child. I just want to make sure that the court gets a clear picture. Isn't that correct?
Yeah, I just walked in because the baby was crying and I asked him if he would want to end it.
Okay. And he was cooperative, was he not?
He was.
Okay. As far as there being any violence or aggression in the visits, has that happened?
No, not in the one visit I saw.
Okay. Thank you. I pass the witness.
Any other witnesses, Ms. Levy?
No, Your Honor.
Anybody else have a witness to call?
No, Judge.
All right. Before I hear from the ad litem's, any requests to the court?
Your Honor, given Mr. Saldivar's request for child support, I would ask that the mother be ordered to pay in-kind child support. The way it's set up, foster parents would never receive the money anyway. It'd be held up in a trust account somewhere for the state and not even benefit the child. So if we're talking about actually benefiting the child, it makes more sense for them to provide clothes, diapers, wipes, food, things that the child can actually use. I'd also ask the court to order Mr. Miller to refrain from reaching out to Ms. Jenkins. His communications with the mother have been extremely inappropriate and threatening and aggressive. And at this point, the parents are not together. There's no need for them to have any communication. So I would ask the court to make that an order today.
All right. Anyone else?
Judge, I agree with what Ms. Savage is saying. And if the court is inclined to put in place any sort of no contact order, I would request it go both ways. These parents are toxic together and they trigger each other. So it's not him, it's not her, it's the two of them. And so I request that whatever order is in place, it's reciprocal.
All right. Anybody else? Mr. Saldivar?
Judge, Jordan's doing well in placement. I have no concerns. Foster mom's keeping me up to date. She's meeting all his needs. I do have concerns, Judge, that we're at this point in the case and we still don't have acknowledgement from the parents on how Jordan sustained his injuries. We have the parents continuing to engage in domestic violence. We have text messages that are violent. We have the father with a gun. It's very concerning that we're showing these or we're getting these messages from parents. Just has to make arrangements. Father's not he's not exercising his visitation at this point, so I would ask that it be modified to at least 48-hour notice. I'd ask that Mr. Miller travel to the child. I don't want to put the child in the car for over an hour to accommodate the parents' visits, and I'm okay with in-kind child support at this time, Judge.
All right. Casa?
I've observed some of the visits with the mother, the virtual visits. And on 2 occasions, she's had other people there. I don't think it's appropriate for her to have other people there without previous permission.
All right. Anything else, Miss Jewel?
Well, I foster mom informed me that after the visit with the father, the baby returned to some of his trauma antics that like, for example, when he was in the nursery at church, everybody said he just screamed every time they put him on the changing table and tried to change his diaper. Same with her mother. Her mother tried to change his diaper and he started screaming. He had stopped that prior to the visit with the father.
Okay.
Otherwise, he's doing quite well. And he's definitely bonded with the foster mother. And she's about the only one that can calm him down besides her husband.
All right. Thank you, Miss Jewel. Miss Levy, you have your hand up.
Yes, Your Honor. My client is asking that she not be required to transport the father given the level of violence and threats in these messages. And I know I was a little slow on it, but I would like to call the mother if there is still time.
Very briefly.
Now, how did Jordan sustain the injuries that brought him into CPS care?
So we were back and forth all day, and I was going to change him. And when I was going to change him, his arm had looked like it had went out of socket. So we had all came together, decided it was best to take him to an urgent care or a hospital. So we did. And when they did the x-rays, that was when only at the time they had said 1 broken bone. And then when we had taken him to pediatrics, it was 4.
Okay. And do you understand why it's concerning that you wouldn't know how your young child sustained 4 broken bones?
Yes, ma'am.
Okay. And is it still your testimony today that you have no idea how those injuries occurred?
To my knowledge, I still don't know. I mean, I have an idea, but I'm
And what's
not.
your idea?
Judge, I'm going to object to speculation. Either she knows or she doesn't.
She can state her opinion, Your Honor.
Well, I'm going to sustain the objection because I think we're about to go down into a line of questioning and everybody's going to want to cross and we just don't have the time for it today. This is a progress hearing. I understand what you're going for, Ms. Levy. I think I heard what I needed to hear for the point of this hearing. So do you have any other questions, Ms. Levy?
No, Your Honor, I'll pass. Thank you.
All right. All right. I'm going to close evidence at this time. I've heard what I need to hear for the progress hearing. Court finds for the purposes of the progress hearing that both parents are in compliance as of today. I'm going to make some orders and then I'm going to give some of my thoughts to the parents. Hopefully it'll make a difference and do some good, but I'm going to grant the order for Mr. Miller to engage in anger management, but we're going to start with his therapist. So if Ms. Artuche, we get down the road a few weeks and you feel like his therapist is appropriately addressing anger management with him, then we're going to keep going down that road. But if you feel like he's not engaging in the anger management with his therapist, and I want you to talk to the therapist, please, or he's not showing up, then we're going to flip it to standalone anger management. And so it's contingent on that. We don't have to come back to court. If he's not going, let the court know, and then I'll tell everybody, okay, as of today, he's doing anger management in a standalone program. So, Mr. Miller, I'm giving you the opportunity to keep your service plan as streamlined as possible by making that order. So it's up to you whether or not you want to keep it that way or you want to burden yourself with more time in another program. I'm going to issue the no contact order between the parents. I don't like doing that. I'm not a big fan of it, but it's clear to me from what I've heard today and the reason I set this progress hearing in the first place is that I think separately, you both can probably pull this off and be good parents. Together, you can't. If we're sending these text messages in a CPS case, I can't even imagine what was going on before we got here. So I'm going to order that you have no contact with each other. And that means any form of communication whatsoever. And if you get into a situation where you just feel like you have to contact the other one, don't, because I'll hold you in contempt if I find out about it. For the purposes of the progress hearing, the court will order the father to continue confirming visits 24 hours in advance. And I'm going to add an order that if for some reason the visit becomes inappropriate, and I don't just mean somebody disagrees with the way the father is doing things, if it becomes unsafe and not in the child's best interest, then the visit can be stopped. And I'll address that more in a moment. I have reservations about ordering the father to travel to the child for a visit, knowing that transportation may be an issue, because I think I'm setting him up for failure. And I also know that the department doesn't wish to transport him because of danger concerns. So we're kind of in a little bit of a pickle here with that. So I'm not going to order him to travel to the child unless there becomes another problem. So what that means for you, Mr. Miller, is if you don't confirm 24 hours in advance or you miss a visit, then I'm going to change it. Then I'm going to force you to travel to the child. And if you can't get there because you can't get a ride, then that's on you. I'm giving you the opportunity to continue to have the child come to you. And it's up to you whether or not you want that to continue. I'm going to order both parents to pay in-kind child support to the value of $150 a month starting June the 1st. I would really like to know that you care enough and that instead of waiting until June the 1st, you go the extra mile and you start giving some in-kind child support now. And that means in-kind, your attorneys can explain it to you, but it means you can give them money, you can give them diapers, you can give them food, whatever it is that will help take care of your child, you're doing it. I'll review the child support at the next hearing. And if you're not providing any in-kind child support when we come back, you're probably going to wind up with a bona fide child support order at child support guidelines that if you don't pay, you can be found in contempt for not paying. And that no contact order is reciprocal as requested. I think I've addressed every concern that I've heard this morning. Now I want to say something. I'm going to be brief because I'm over time. But before I leave, we'll be back July 17th, 2024 at 11:30.
And Judge,
July 17th, 2024 at 11:30. Yes, ma'am.
Can we have DNA ordered, please?
Ordered.
Thank
Let's
you.
put a DNA order in there too. I want that done as well. Now, Mr. Miller, I want you to listen to me very closely because I'm only going to say this to you one time. I have 5 children and I have 3 that are 20, 18, and 17. So I'm not so far removed from your demographic as to not understand how much you have on your plate at 20 years old. I get it. There's a lot going on, but you have the opportunity right now to make different decisions than what you're making. To hang out with different people than who you're hanging out with. Hang on, put your hand down. This is a time for you to listen. And to engage in this case in a way that's positive for your child and positive for you. Whether or not you choose to do that is completely up to you. But instead of thinking about how things are right now, I want you to imagine what your life's going to be like in 15 years with your child. Imagine what kind of father you want to be in 15 years for Jordan. Do you want to be the kind of father that's in pictures with guns and being subject to no contact orders? And put your hand down. Part of your problem, I think, is that you don't listen enough. You want to talk when you should be listening. You need to ask yourself what kind of father you want to be in 15 years or 20 years or 25 years and what kind of relationship you want to have with your child. Because if you continue to do what you're doing, cussing out Mr. Tuche, using language you shouldn't use, sending threatening texts, that's where you're not going to be where you want to be in 15 or 20 years. You're just not. And I understand that you're at an age where you probably think you know more than I do, but you don't. Miss Jenkins, reciprocal no contact order, it's reciprocal. So that means you don't send anything to Mr. Miller. You don't call him, you don't text him, you don't email him, you don't snap him, you don't do anything. Do you understand?
Yes, sir.
All right, Mr. Saldivar.
Judge, I have a concern if dad's requesting DNA. Typically, we don't do visitation when a father's waiting for DNA, Judge. I don't see how it's any different in this case. I would just ask the visit be suspended. If he doesn't think that he's the father, he's going to the extent of asking the court to pay for a DNA test. Judge, I'd ask the visits be suspended until we get the results of that test.
What's your response to that, Ms. Swallow?
I absolutely do not agree. He's been there for the mother. They were together. He thought he was the father. Some things have come to light to where he questions the mother. I don't want to go down that road in this hearing, but I think it's prudent for him to have that DNA test. And
All right,
I don't
he's
think
gonna have it. He's gonna have it. We're gonna do the DNA test. Overruled, Mr. Saldivar. Ms. Rabson.
Judge, could the mother's virtual visits be for her only at this time rather than
Yes.
including all of her family?
Yes, Ms. Jenkins, it should only be you in the camera and there should be nobody else in the room. You're supposed to be bonding with your child right now and you're doing it remotely, which is already an issue. Don't have anybody else in the room. All right. I want to encourage both of these parents at this time. And I'm offering you both the opportunity through some of these orders to straighten out some of the things that are going wrong at this time and get to a point where we're making good progress. You both have made progress since we were here in April, and I'm proud of both of you for making that progress, but we still have some issues and we need to get those worked out. Mr. Miller, I see that your hand is up. I'm way over budget on time. I want you to talk to your attorney after this hearing. And if your attorney feels like whatever it is you need to say needs to get to me, she'll make sure it gets to me, okay? All right. I'll see you all back July 17th at 11:30. Thank you for your time and your service. All parties are excused.
Thank you.
Okay, I still don't have any contact from Mr. Weatherby or Miss Acevedo. Were you all able to come to any sort of agreement with the mother?
Yes, Your Honor, the mother's in agreement to temporary managing conservatorship with the department. There's a visitation agreement for 1 hour a week for the first 2 visits.
Let me hang on just a second before you get into the details. Let me get to a point where I need to call the case and get all this on the record. Miss Levy, would you please begin the announcements?
Leslie Levy, attorney for the department. State is ready.
Alana Pearsall, attorney for the mother of Brittany Hyatt. Ms. Hyatt, can you please unmute and introduce yourself to the court?
Yes, my name is Brittany Hyatt.
Miss Hyatt, can you turn on your video or no?
I don't want to be on YouTube, but if you would like me to, yes, I can.
Well, this is a public court proceeding and I need to see you, so
yes, sir.
Unfortunately, that's part of it. Thank you.
Hi. Yes, sir.
We can continue with the announcements, please.
Cynthia Ravago, family-based caseworker for the department.
Carol McKetta, family-based supervisor.
Kathleen Savage, attorney ad litem for the children. Your Honor, I'm ready.
Goldie Rabson, Hill Country Casa, guardian ad litem for the children.
This is Jerry Garcia.
All right.
Father Villana.
Thank you, sir. Now I need you to keep your video as still as possible and keep your video on, please. All right, Miss Levy, before you put the agreement on the record, court wants to make a note that we do not have Mr. Weatherby or Miss Acevedo present with us, nor do we have Mr. Bazan. So therefore, I'm only going to enter orders as to Miss Hyatt, unless Mr. Garcia wants to move forward without the benefit of counsel. Mr. Garcia, have you had a chance to talk to Mr. Weatherby about this case?
No, sir, he has not been in contact with me.
Okay. Let me hear the agreement, and then we can talk about it, Mr. Garcia, and see if it's something you want to agree to without the benefit of counsel. But Ms. Levy, if you would go ahead, please.
The mother is in agreement to temporary managing conservatorship with the department. And with visitation to be once a week, starting at 1 hour, supervised by the department. If Miss Hyatt is compliant with the full visitation for those first 2, the visits will expand to 2 hours a week, with the law having the authority to allow family visit family to supervise the visits, assuming they all go well, or to supervise themselves. And I believe that is the full extent of the agreement that was made with the mother.
Okay, did she agree to a family group conference?
We did not discuss that, but I think that would be wise.
Judge, if I can address that.
Go ahead.
So the issue was the length of the visits, just to give the court a little bit of background, I'm sure you've read the affidavit. His mom has been severely injured and was in the hospital. And so she is in a lot of pain. So we like physical pain from her injuries. So we want to make sure she had a visit. I don't know the date, so I don't want to give the wrong date, but she couldn't make it for a full hour because of the pain. So she's slowly recovering. We want to make sure that she can last for an hour. So assuming she can last through an hour despite her pain, then it'll be increased to 2. She has already started working services. She has been working services. This is not a non-compliance issue. So she absolutely will agree to FGC, and we actually want it as soon as possible. However, we do want it to be virtual because she's in a lot of pain, and you can tell she's lying down, and that's for medical reasons. She's in no way, being disrespectful to the court. So I want to make sure it's virtual. But yes, we want it, and we want it as soon as possible, so she can continue doing everything she can do to get reunified with her base.
Okay, thank you. What I would be, well, let me first ask, everything else in that agreement is what you agreed to, Ms. Pearsall?
Yes, Your Honor. There was also, I'm sorry, no child support.
I'm going to defer any of that at this time, especially since she's in the hospital. Ms. Savage?
Yes, Your Honor.
I'm sorry, just to be clear, I don't want to mislead the court. She's not in the hospital. She's been released from the hospital, but she's, she's recovering from pretty severe injuries.
Understood. Thank you. Hang on, Ms. Hyatt. Go ahead, Ms. Savage.
Your Honor, I'm in agreement to the proposal. The children are placed with family and they are doing well, and I believe that placement should continue at this time.
All right. Casa?
CASA is also in agreement, and the children are doing very well with family at this time. However, the family could use all the assistance they can from the parents.
Okay. All right. Mr. Garcia, now you've heard the agreement that was stated on the record. And again, you're here without, you were appointed counsel. We always appoint counsel for the first appearance. You haven't had a chance to talk to your attorney, and your attorney's not here. So having heard the agreement, is this something you're willing to agree to as well, or do you want to talk to your attorney first?
No, that sounds good to me.
Are you sure? I'm not trying to talk you out of it. I'm just trying to make sure you understand that I've appointed you an attorney and your attorney is not here, and you have not had the chance to talk to your attorney. If you are okay moving forward with the agreement, all I have to do is make sure it's on the record and it's very clear that you're voluntarily waiving your right to talk to counsel and making this agreement.
Yeah, that's fine with me, Your Honor.
Okay, then Ms. Hyatt, you've heard the agreement. Before you ask me your question, based on what Ms. Levy said and your attorney said, is that the agreement you made?
Yes, sir.
All right, now I'm going to ask you, Ms. Hyatt and Mr. Garcia, both of you at the same time. Are you both entering into this agreement voluntarily?
Yes, Your Honor.
Yes, sir.
Have either of you been forced in any way or made any promises to get you to agree to it?
No, sir.
No.
Do you both understand what's expected of you in this agreement?
Yes, sir.
Yes, sir.
All right. Then for the purposes of the adversary hearing here today, have either Mr. Garcia or Ms. Hyatt been served? Do you know, Ms. Levy?
I do not see a return of service for either of them.
Okay, then I'm going to find that based on their appearance here today and their agreement that they made on the record, that they both have made an appearance themselves and through Ms. Hyatt through counsel, and Mr. Garcia waived counsel and made the agreement voluntarily.
And I'm sorry, I do have a return for Miss Hyatt.
Okay.
I do
I'll
not for
take
Mr. Garcia.
Okay, thank you. I'll take judicial notice of the return of service for the mother Hyatt and also find again that she has made a general appearance by and through her counsel and through an agreement. Court will find pursuant to chapter 262. Actually, let me ask a few questions. We haven't gotten to this yet. Ms. Rabago, could you please unmute?
Yes, Judge.
You heard the agreement this morning.
Yes.
You believe it's in the best interest of the child
Yes.
and the children, excuse me. And do you believe that the placement of the children is safe and appropriate, meeting their needs?
Yes.
And is everything that you stated in your affidavit in support of this case, to your knowledge, still true and correct?
Yes.
All right. Do the parties stipulate as to the reasonable efforts made by the department in this case?
Yes, Your Honor, but I have a few questions for Ms. Rabago.
And you said yes, Ms. Savage?
Yes, Your Honor.
Okay. Mr. Garcia, you're not here with counsel, so I have to ask you directly. The state is required to make all reasonable efforts to avoid a removal and to return the child home. In this case, the parties' attorneys have agreed that those efforts were made. I know it's probably confusing for you, but by virtue of your agreement, do you also agree that the state has made reasonable efforts to avoid a removal and to return the children home in this case?
Yes, Your Honor.
Okay. And if you don't understand that completely, I understand, but it's part and parcel to your agreement. Ms. Pearsall, you may question Ms. Rabago.
Ms. Rabago, Mr. Garcia is the father of which child?
Ayana.
Okay. And how old is Ayana?
She's 9
years.
9 years old.
Okay. And do you know where Mr. Garcia is currently located?
I don't have his address in front of me, but yes, he's in the Houston area, I believe.
Okay. Is he in a halfway home?
Yes.
Okay. And prior to that, he was in prison?
Yes.
Okay. Do you know when was the last time he had any contact with his daughter?
I don't know.
Has it been years from the information you've gathered?
Yes.
Okay. To the best of your knowledge, does Ayana have any idea who he is?
She does have an idea of who he is.
Okay. Now the questions.
Ms. Levy, any questions for Ms. Rabago?
Ms. Rabago, your knowledge, is there any Native American ancestry in this case?
Not to my knowledge, no.
And have you been able to ask any of the parents or relatives that?
I have not asked Mr. Garcia.
And can you follow up on that after this hearing?
Yes.
Thank you. Nothing further, Judge.
Ms. Savage?
No questions, Your Honor.
Considering the testimony of Ms. Rabago regarding the relationship between Mr. Garcia and his child, it sounds like there's some distance there. Do you all have any sort of proposal as far as how that visitation should be initiated?
You know, I'm asking that it be by therapeutic recommendation. My understanding is this kiddo has no idea who Mr. Garcia is. And so I just don't want to traumatize her, you know, by introducing somebody she has no idea about. So I'd like to make sure it's therapeutic, so it benefits her.
Your Honor, I would ask that maybe the first couple be in a therapeutic setting. I don't know if I want to wait until we get a therapist recommendation. We have a 9-year-old. Her father is someone she's entitled to know. I do want to make sure there's protections in place, but I think that's a relationship. He's shown up. You know, I think that she is entitled to try to get to know him and have him a part of her life. So I would ask that it be in a therapeutic setting. And if for some reason it have to be stopped, we stop it. But I don't want to wait for a therapist recommendation and then we're 6 months in and it's just further delayed her getting to know her father.
Mr. Rabson?
CASA is in agreement with the attorney ad litem's recommendation.
I am too. I understand Ms. Pearsall's concerns and I think that they're valid. But at the same time, as Ms. Savage stated, Mr. Garcia has shown up here today voluntarily. He hasn't even been served yet, and he's willing to work services. So I'll make an order that comports with those circumstances. For the purposes of the 262, the court finds there's sufficient evidence to satisfy a person of ordinary prudence and caution that there was a danger to the physical health or safety of the child caused by an act or failure to act for the person entitled to possession, and for the child to remain in the home is contrary to the welfare of the child. The urgent need for protection required the immediate removal of the child, and reasonable efforts consistent with the circumstances and providing for the safety of the child were made to eliminate or prevent the child's removal, and reasonable efforts have been made to enable the child to return home, but there's a substantial risk of a continuing danger if the child is returned home. Court will name the Department of Family Protective Services / Belong as a temporary managing conservator. Court will name the mother, Brittany Hyatt, as a temporary possessory conservator, and the father, Jerry Garcia, as a temporary possessory conservator. Court makes no orders today as to Bruno Bazan or the unknown father. Court finds that the placement of the child is safe and appropriate, meeting the child's needs and in the child's best interest to continue. Court will order that the mother's visitation to be 1 hour per week, supervised by the department to begin, provided the first 2 visits go well and she's up to it. I understand she's having some health issues now. Then that will increase to 2 hours per week, and I will give the Belong the authority to allow appropriate family members to supervise. Court will order that Mr. Garcia have supervised visitation as well. In a therapeutic setting to start at. We're dealing with children that they're not infants. So I think twice a month for an hour to start is appropriate. So he'll have visitation with his daughter twice a month for an hour, supervised by the department. And parties are ordered to hold a virtual FGC to develop family plans of service that are narrowly tailored to address the concerns that brought the children into care and that are in the best interest of the children. Court will defer any findings towards or orders toward child support or medical support at this time. I will also need to make indigency findings. Ms. Hyatt, I understand you're overcoming injuries right now. Are you able to work, or do you have any money at all that would allow you to pay for an attorney in this case?
No, sir. I actually just got out of the hospital yesterday. The reason why I wasn't able to withstand the hour when I was in the visit with my children was because I had a blood clot that actually got infected in the leg that was injured. So I actually had to rehab surgery. So
Okay.
I have been in the hospital
All right.
So I just got out yesterday.
Okay. Thank you for that information. I understand. So I'm going to continue to find that you're indigent for purposes of this case, and we'll continue to have Miss Pearsall represent you. Okay. Mr. Garcia,
yes.
Could you unmute for me, please? I had to mute you just to cut down background noise. Do you have the funds available to pay for an attorney at this time to represent you in this case?
No, sir, I don't.
Do you have anything saved, or do you have any assets that you could sell that would allow you to pay for an attorney?
No, sir, I don't. I just got out of prison. I'm currently in a halfway house going to school and just trying to figure out my life.
Okay, well, that's good. I'm glad that you're on the right track, and I will continue to find that you're indigent for purposes of this case, and we'll continue Mr. Weatherby and his appointment of you. And my coordinator has reached out to your attorney to make sure he knows that he needs to get in touch with you. Okay.
Yes, sir.
All right. We'll be back for our status hearing June 26th, 2024 at 11 a.m. June 26th, 2024 at 11 a.m. Ms. Hyatt and Mr. Garcia, that status hearing, you're going to use the same link that you used to log in today. So hang on to it. Okay. All right.
Yes,
Ms. Levy, besides the admonishment, is there anything I failed to address?
Your Honor, can you order that the FGC be set up as soon as possible and virtually, please?
I've ordered it to be virtual, and yes, as soon as possible. Y'all need to get that on the books. All right. I have to admonish both the parents. The state of Texas gives parents in CPS cases 12 months to demonstrate that you can provide a safe, stable, violence, and drug-free home for your child. In the event you cannot demonstrate that, your rights to your children or your child could be subject to further restriction, as they are now, or termination. So the clock's ticking. Make sure you get involved with your caseworker and your attorneys and any other resources that they refer you to, and get these things done. Okay. That will conclude this hearing. Thank you all for your time and your service. If nothing further, you're excused. Judge Morris will be taking over the remainder of the docket today. I will see you all next week. Thank you.
Thank you, Honor.
Department of Family and Protective Services versus Welge. This is a case out of Gillespie County for court-ordered services. Hearing is being conducted via Zoom. I'm visiting Judge Morris, and we'll go ahead and start with announcements starting with Ms. Levy.
Leslie Levy, attorney for the department.
Kathleen Savage, attorney for the respondent mother, Millie Welge. Miss Welge, can you unmute and announce your name for the record?
Millie Welge, the mother of Adeline.
All right.
Richard Saldivar, attorney for the child.
All right. Thank you, Mr. Saldivar. Let's see. And who's the caseworker representative?
Irving Santiago Chavez, investigator for the department.
Okay, you're an investigator. Okay. And
President Mitchell, investigation supervisor.
Okay, Ms. Mitchell.
Taylor Gonzalez, family-based caseworker.
All right. So, Ms. Levy, you may go ahead and proceed.
Thank you. I would call Mr. Santiago. And you're the investigator on this case?
Yes, ma'am.
Okay. Are you familiar with the respondent mother's previous CPS case?
Yes, I was the investigator during that case as well.
All right. What were the allegations in that case?
Regarding physical abuse.
Your Honor, I'm going to object to relevance as to this case and in this investigation. I don't understand what a case from before the child was born is relevant to today's hearing.
I think your objection. I think that the history is very relevant, so you may proceed. Let's not go into a lot. I don't think we need to go into a whole lot of detail, but I think we can address it. All right, go ahead, Ms. Levy.
Thank you. Mr. Santiago Chavez, could you go into the allegations from the previous case?
Yes. The allegations were regarding physical abuse. There was a video of the child's father.
Hearsay.
Your Honor, he observed the video and he can testify to what he has seen in it.
In one of the videos,
Mr. Santiago Chavez, if you could hold on for a ruling from the judge.
I'll overrule it, but just try to be very brief on this, Ms. Levy.
Yes, ma'am.
Okay. There was a video. It was a nanny cam video. The father, Andrew Lippert, was shaking the crib. The baby's face was observed like hitting the crib multiple times. There was a second video also of the father walking into the house and just dropping the child on a mattress. There was, in both of those videos, Ms. Welge was seen. That was what the allegations came in at the time.
Okay. Were there pretty serious concerns that mother knew about the extensive abuse?
Yes, as the mother was seen in both videos.
All right. Did the mother take any protective actions at all?
No, she did not object to anything that was witnessed in the videos.
Now, did the mother work any services in that previous case?
To my knowledge, after the child was removed, she was, family needs and strength assessment was completed and she was recommended to complete services. To my knowledge, she did not complete any of those services.
Is it your understanding that instead she relinquished her rights, ending that case?
That is correct.
How long ago was this event?
This happened around March of 2023.
Okay, so just a little over a year ago. How old is the child in this case?
In the current case, the child is a newborn, was born last month.
Now, do you believe that there is that child abuse or neglect is likely to occur if services aren't worked to support the mom and rectify some of the issues from this pretty bad history?
I do.
And are you asking for therapy, a psychological and mental health services as part of this family-based case?
Yes.
And is it your understanding that the mother is in agreement to the Parents as Teachers program as well, which is part of the Texas Family First pilot program?
Yes, ma'am.
Okay. And do you believe that these services will be in the best interest of the mother and the child and hopefully prevent a removal in the future?
I do.
Your Honor, I'll pass the witness.
Ms. Savage?
Mr. Santiago, the mother is no longer in a relationship with Mr. Lippert. Is that correct?
That is what she reported to me.
Okay, and you've been involved and in communication with Miss Welge since March, shortly after the baby was born. Is that correct?
Yes, ma'am.
Okay, and during that time, you have not seen Mr. Lippert around or with the mother. Is that correct?
That is correct. Yes.
Okay, and Miss Welge has been participating in services and going to Heart of Hills. Is that correct?
Yes, some parenting classes. Yes, ma'am.
Okay, and it's been reported that she is engaged and she is cooperating with that program, correct?
Yes, ma'am.
Okay, and Miss Welge is remaining and living at her grandparents' home at this time. Is that correct?
Under a safety plan, yes.
Okay, but she was there and living there prior to the safety plan being implemented, correct?
Yes, ma'am.
Okay. And actually, she's been compliant with the required safety plan, even though there's not been any allegations of abuse or neglect as to Adeline, correct?
Correct.
The department is simply involved because of their concern as it relates to the prior case, which occurred a year ago, correct?
Yes.
And as you stated, it was Andrew Lippert who was the prime perpetrator of the abuse, correct?
Yes, of the videos, yes.
Okay. What mental health issue does Ms. Welge have, to your knowledge, that requires mental health services?
So my knowledge is based off of the psychological evaluation that was performed during the last legal case. It was she was diagnosed with major depressive disorder.
Okay, and that was following delivery of her first child, correct?
That was during the legal case after the removal.
Okay, but you have no knowledge of her needing any mental health services at this time, correct?
Yes.
Okay. Would you agree that the main concern for the department is her parenting abilities, and that would be addressed through the PAT program?
Parenting and protective capabilities, yes.
Okay. And again, there's not been any allegations that she's done anything or put Adeline in any kind of danger since Adeline's been born, correct?
Not to my knowledge, yes.
Okay. I'll pass this witness, Your Honor.
Mr. Saldivar?
Yes, and so going back to the videos, Mr. Lippert was the one that physically abused the child. However, did Miss Welge make any effort to protect the child while Mr. Lippert was physically abusing the child?
No, sir.
Did she exhibit any type of protective capacity in those videos?
No, sir.
And to your knowledge, was Miss Welge aware that Mr. Lippert was charged with a felony to the injuries that he gave that child?
Yes.
And she made the conscious decision to have another child with him. Is that correct?
Yes.
Okay. So even after her relinquishment, to your knowledge, do you believe that she maintained a relationship with Mr. Lippert for a while?
She reported that she did, yes.
Okay. And that's knowing that he was being charged with a felony. Is that correct?
Yes.
Does that give you concerns of protective capacity?
Yes.
Was she aware that Mr. Lippert also relinquished his rights?
I don't have knowledge of that, but I'm assuming yes.
Okay. And since since Ms. Welge didn't address any of the concerns of the prior case, are you concerned that those protective capacity issues are still there for this child?
Yes, sir.
Pass the witness, Judge.
Right. Any further questions of this witness, or do you have any other witnesses, Ms. Levy?
No, Your Honor, the state would rest.
Let me just ask you this. I know that you all have conferred. Was there any part of this of these services requested that you all reached an agreement about? Because it sounds like from what Ms. Savage's questions that perhaps there might have been some partial agreement.
Yes, Your Honor. Ms. Savage was in agreement to the Parents as Teachers, the TFF pilot program, and protective parenting, which is essentially what Parents as Teachers is. I don't believe she was in agreement to any other services.
Right. Do you want to add anything to that, Ms. Savage?
Your Honor, that's correct. Department's using this case as a fishing expedition. They're basing the whole reason for their involvement from the case that happened over a year ago. Miss Welge's situation is completely different. She's no longer in that relationship with Mr. Lippert. She's cooperated with the department. She's willing to do the Parents as Teacher program, which has someone in her home every week. We're going to have continued hearings. I think that at this time we order the TFF, start with the PAT program, start with the protective parenting. And if that provider who is meeting with Miss Welge and her child on a weekly basis feels that there's an extra need for her to have counseling or mental health, then we can come back and have that ordered at this time. But for the department to come in, say a year ago, she made terrible decisions and we're going to ask her to do all these things again. It's not valid. It's not basis. There's nothing that has been presented today that has said that Adeline is going to be abused or neglected, or that Adeline has been abused and neglected. She's living at her grandparents' home. That's going to continue. We can agree that that be part of the order, that she not move from there, and that Mr. Lippert has no access to this child, which she's already doing on her own and showing that she's being protective with that step alone. So I would just ask that the TFF be ordered and the Parents as Teachers be ordered, but that no additional services be put on the plate of Ms. Welge when the main service is making sure she can be a hands-on parent with her child.
All right. Thank you, Ms. Savage. And just let me ask this. Do you know when she had a psychological evaluation prior, what the date was on that? Does anyone know that?
Believe it would have been around April or May of last year, Your Honor.
Okay.
I believe Ms. Gonzalez might know that. She was nodding her head.
Okay. Well, I'll get back to her, but let me hear from Mr. Saldivar. What are you? I didn't really ask you specifically, Ms. Levy, but I think I know what the department is asking for. Mr. Saldivar, what's your recommendation in this case as attorney for the child?
Judge, as far as placement right now, she's placed with her great grandparents, I believe. And I went out to the home. It's appropriate. I think they're protective. They will watch Miss Welge if needed, and I think that they can safely do that. As far as services, Judge, I'm in agreement with the department. The last case was a really horrible case. This was on a sibling just a year ago. Miss Welge was well aware of what happened. She was present during the physical abuse of the child. She did nothing to protect her child. It was only when faced with an aggravated circumstances hearing that both parents relinquished right before the hearing, Judge. The parents, Miss Welge knew that there was an aggravated circumstances hearing. She knew that Mr. Lippert was facing felony charges related to the abuse of that other child. He ended up taking a plea deal on it, and she still made the conscious decision to have another child with the perpetrator of the abuse of her other child, who she was terminated on. Judge, I don't think that Miss Welge has the protective capacity at this moment. I believe that if we provide her with all the services necessary, that we can get to a place where she can learn from what happened and to be protective of this child. But to minimize that, there's no new allegations in this case, Judge. I mean, she made the conscious decision to move forward and have another child with a man that basically cracked the skull of her child for absolutely no reason. Based on that, she needs every service that I could imagine so that she can understand what happened and how to protect this other child going forward, Judge. So I'm asking you to agree with the department and order what they're requesting, Judge.
Right. And so, Ms. Levy, what specifically are you requesting in addition to the things that were mentioned by Ms. Savage, the TFF, the Parents as Teachers, the living arrangements, and no access with the father? Those are the main points I got that there was an agreement on. What additional services is the department requesting?
We are requesting mental health services, which I believe she already has an appointment set up for the mental health psychiatric treatment services, as well as a psychological. And because you asked, I don't believe she did a psychological, she did a psychiatric evaluation back in June of 2023. So we are asking for the psychological and to follow all recommendations, as well as individual therapy.
Okay. All right. Is there anything that anyone would like to add at this point? I think we've kind of covered the bases. All right, and I'm not sure how it works on these cases. Does CASA get appointed at the initial hearing? I don't know if you can answer that question, Ms. Rabson or Ms. Levy.
No, Your Honor, CASA's not on a court-ordered services cases. It's just the ad litem.
Okay, I just want, yeah, since y'all are here, I just wanted to make sure I didn't need to address that issue. All right, so at this time, the court does, after hearing the testimony, court does find that there's sufficient evidence to order court-ordered services in this case. I will order that Ms. Welge, that you continue that working with the TFF and the parents as teachers. I think that'll be a really great service. As Ms. Savage said, they'll be able to come in your home and help you work with your baby actually being there present with you. I'm going to order that you continue your current living arrangement. If that some reason that falls apart, you need to make sure you contact your caseworker immediately. And that the child, of course, is to have no contact with Mr. Lippert. In addition, it sounds like you have an appointment with MHDD. Is that correct? Okay, you need to make sure you keep that appointment and follow those recommendations. In addition, I will order the psychological evaluation and individual therapy. From what I understand from the testimony, it was a very serious case that happened within a year, is very recent as far as I'm concerned. And it sounds like there were no services were participated in the last case. So there's no reason to believe that there's been any progress made since that case occurred. So I think that the protective capacity is what I'm concerned about. And even though you don't have a relationship with Mr. Lippert now, you probably will have future relationships with other people. And I think that it's important that you have individual therapy to address those issues. The psychological evaluation is basically just a one-time thing, but then they may order additional services from that. And as Ms. Savage said, we'll be having continued hearings on this, so we'll be able to follow the progress. Ms. Wilgie, I'm asking you, do you understand the court's order today? I take it as a yes. Ms. Wilgie is nodding yes. So I take that as her acknowledgement that she understands the court's order. I believe the next hearing will be July 25th at 11:30. And we'll see how quickly can the parents as teachers services begin. Does anyone know the answer to that question?
She will be enrolled within 10 days.
Okay, that's good. All right. I think that I understand that the points that Ms. Savage is raising. However, this is a very, very young child, a newborn, and the other child was very, very young. And I think that it's important that intervention occur quickly. And hopefully if things continue to go well, then we can get out of this case quickly. I think that's your best bet, is to demonstrate to these providers that you understand the concerns in this case, and that you're able to be an appropriate and protective parent. So I wish you the best of luck. And if nothing further, we will be dismissed until July 25th at 11:30. Anyone else have any questions or comments?
No, Your Honor.
Okay. All right. Thank you all. And then I think we have another hearing at 1:30. Is that right?
Yes, Your Honor.
Okay, at 1:30. So we'll be excused till then. And I'm assuming we'll leave the site until that time.
And I'll bring it back at 1:30.
I would like to have announcements. All right, we'll start with Ms. Levy. And let me just hear from the attorneys first and tell me whether what it is you're recommending today. So go ahead, Ms. Levy.
Thank you, Your Honor. The department is requesting that the family participate in court-ordered services. There's been some pretty serious concerns for domestic violence. I know that there are temporary orders being sought by some of the parents in this case. But in the meantime, the department is asking that the family complete services and that a parental child safety contract be put in place with the 3 youngest children.
Okay. And I did review the affidavit presented, and I do think the concerns are serious enough that they warrant us at least paying some attention to it today. Ms. Swallow, what is your understanding of what you and the department have agreed to?
Judge, I concur with the department. I believe that these parent-child safety plans they have to happen, or this needs to be a removal. This case should already be a removal, in my opinion. But if the department wants to continue to try to work with this mom, this is their pleading, their case. But we absolutely have to have 3 parent-child safety plans, very strong ones in place to protect these children. I do not trust that without them, the mother would not try to figure out a way to pick up these kids. And there's nothing in place right now to protect them.
Okay. So have you all discussed possible safety plans?
We do have, the youngest is with her paternal aunt. She's been with her for almost maybe 2 months now, over a month. The twins, the middle 2, they are with their alleged father, and they've been with him for possibly about 2 months now. And then the oldest is with his father, and the oldest has temporary orders that protect him and that call for possession and access. So I'm mostly concerned right now about the youngest 3.
And do you think that the current arrangements are appropriate for those 3?
I do, Judge. They cannot be returned to the mother at this time. She's got to engage in services. And I believe that the father to the middle 2, he's here, Mr. Michael Wade. He's protective and cares about about the twins, but there's nothing in place to protect her from coming and picking them up. Same with the youngest.
Okay.
Judge, if I could respond.
Okay.
The mother is in agreement. She's in agreement with the motion to participate. She's in agreement with placements. Well, they're not really placements because this is a motion to participate, but with the children remaining where they are under a safety plan. The only issue is the mother would like visitation as she supervised by their placements or the department for up to 4 hours per week. So what I'm hearing and reading via email is the only issue is, should visitation be 1 hour per week or 4 hours per week?
Okay. Now, do we have, who's the other attorney? Ms. Yanis, what is your position via your client?
Mr. Tilley, the father of Charlie, the baby, has agreed to engage in services. He has agreed to a psych eval, which he's already done, individual therapy, parenting, sign a release for those services, and follow the PCSP, which he's agreed to. The child is with his sister. I have been in contact with the department, and they agree that he can continue make contact with his child as he has been having contact in the past, as long as he does not facilitate visitation for the mother.
Okay. And thank you, Ms. Yanis. And what is your position on the visitation, Ms. Swallow?
Judge, I think that it's been working for Mr. Tilley, whatever he's been doing with his sister. He goes on the weekend and he goes to church with them. That's working. There's no threat. There's no issues there. As long as he knows he cannot be with her unsupervised or take her. As far as the mother, I believe we start at 1 hour a week, supervised by the department.
Okay. All right. So,
Judge, I want to bring to the court's attention that the allegations aren't that the mother committed any type of domestic violence or abuse against the children. It's that the paramour did. So I don't know why she's being held to a much stricter standard than Mr. Tilley.
And Judge, I maybe I've misread the affidavit, but I believe the department has evidence to show that the mom was directly involved in a lot of the physical abuse that has occurred. She knew, she lied about it. So we can go into that, and it's not going to be good for mom.
And Judge, I would like a continuance, and we'll have a contested hearing because I don't agree with these statements that are being made.
Well, let me tell you, I'm not going to grant a continuance just because you have to go to another court. This case was set today, and it's a very important case. Ms. De La Rosa, please put your hand down. And it sounds to me that there is an urgent need to have some finalization as to at least the safety placements before we leave here today. So I think that needs to at least be firmed up, and that there should be an order in place memorializing those safety plans before we leave today. It sounds like the only issue really is the visitation with the mother, and that could be done at a later date. if we can get some of these other things going. I don't see any need to postpone the entire hearing.
Well, Judge, mother hasn't been getting access to her children. So I think that it is imperative that the court make a ruling on her access.
I can make a ruling as to her access right now. And who's the representative investigator or department's representative?
That would be Mr. Baca.
I'm sorry, who's that?
That is me, Cynthia Rabago, family-based caseworker.
All right. Has Miss, I understand from what has been said so far that the children are currently in safety plans or with people who it seems to be appropriate for now. Is that your understanding as well?
They're with people that are appropriate, but there is not a signed safety plan or parental child placement. Yes, ma'am.
Okay. And what kind of contact, if any, has the mother had with the children since this case started?
Since the case started, mom had custody or had the kids with her, and she was engaging in 50-50 custody with each set of the fathers. Then as the case progressed, that changed once we learned of the physical abuse on March 8th.
Okay. And so since March 8th, what kind of contact has she had?
She, with Bentley, he remained in father's care. The twins as well, they remained in their father's care. So she has not had contact with those 3 boys. With Charlie, she still had him, and her and Mr. Tilley were continuing exchanging custody kind of on their own. And then there was a safety plan put in place where Miss De La Rosa's contact was to be monitored 24/7 by her brother, who lived in the home with her and her mother. That safety plan was broken right at, I believe, 29 days, where Mr. Tilley and the brother left the residence and left Charlie with her. So at that point, we were looking to Mr. Tilley to be the protective parent. He had moved in with Miss De La Rosa, and he's not appropriate to supervise contact. So because there wasn't a safety plan monitor for Miss De La Rosa's contact, Johnny was going to move out. He decided he wasn't going to move out after all. We gave him a weekend and then a week, and then he changed his mind and he chose to stay there. So then at that point, we requested that he take Charlie to his sister's house to have some sort of safety. And when he was asked to sign a safety plan or PCSP, he refused.
Okay. So what exactly is his access to his child then?
So currently, since Charlie has been with a paternal aunt, Johnny has been going over on the weekends because he is primary. From my understanding, he had kind of been the primary parent for her, caregiver. So he does go over there when he's not working on the weekends to spend either a few hours with her or the night with her.
Okay. And do you believe that is appropriate?
I believe so, yes. As long as he is not leaving the property with her. As long as Kaylee's monitoring 24/7 and he is not taking Charlie to go see mom.
Okay. And Ms. Swallow, do you think that's an appropriate arrangement?
Judge, I have my questions. The affidavit has information that he has picked up Charlie from daycare before, and that there was an unidentified individual in the vehicle that I believe could have been the mother. I believe that he's aware of the safety plan being violated previously. So, there are a lot of lies in this mess. And I think that for now, he doesn't need to be spending the night there. He can go visit on the weekends as long as his sister is comfortable with it.
Okay. Well, what I would suggest is that today the court would enter an order ordering the services that have been mentioned today, because I don't hear any objection to those services. I would also enter an order ordering the children into a safety placement in their current placements, which I don't think there's any real objection to that either. And at this time, I would, as far as visitation for Mr. Tilley and the mother, what I would suggest is that the mother be given a visit of 1 hour to be to be scheduled within the week, within 7 days. I think it's been too long that she's not been able to have contact. And I think that contact should be supervised by the department. And with Mr. Tilley, I agree with Ms. Swallow's recommendation that that should not be an overnight visit at this time, and that he can go on the weekend as long as his sister is there. My hope would be that if those visits continue to be appropriate, then they could be they would be increased. And as the parents participate in services, that would be increased. I'm going to enter those orders that I have mentioned today, and those will be in effect as of today, even though we won't have a signed order as of today, but you all need to understand that those things have been ordered. If our next follow-up hearing is scheduled for July 24th at 9:30, that would be with Judge Falkenberg. And so if somebody would like to have a hearing prior to that to discuss any of these issues, I think that's something you can schedule with Ms. Greenlee and bring that before Judge Falkenberg. Are there any questions about that so far?
No, Judge.
I mean, I will have to say that I agree with Ms. Swallow. I think these are very serious allegations. I don't presume that everything that's written in the affidavit is true. I realize sometimes, that people may take issue with some of those allegations. On the other hand, it seems like there's a lot of turmoil going on, a lot of conflict going on. These are very young children, and I would also concur that, the reason for these kinds of cases is to prevent removal. And so the last thing I would want to do is to have the department have to take custody of these children or any of the children. And so I think that it behooves you as the mother, Ms. De La Rosa, to participate in those services as much as you can, and so that we can correct these issues and can avoid removal of these children. Do you understand that, ma'am?
Yes, ma'am.
Did you have a question or something you wanted to say earlier?
I mean, I've been working services despite having a family plan. I'm in no opposition against where the kids are at. The department's done a great job intervening, as hard as it is as a parent to be told you need help. Me being my children's mother doesn't make me any better of a parent than their dad. So they are good where they're at. It was just finally getting access to my kids again after not seeing them for as long as I have.
And I agree with you on that. And I appreciate your attitude. I think that I'm glad that you're working services. And what I would say to all the parents, these services are not intended to be punishment for anybody. They're supposed to help you. And I can see by looking at you that you all are very young. And I think you got Ms. De La Rosa, you got a lot of kids. That's hard. It's a hard job for anybody. And so I think that the services that are provided can only help you. They're only going to help you be a better parent. And I think that one of the best things is if you can work together with the fathers of the children, and y'all can be, kids need both of their parents, and they need their aunts and uncles and grandparents and everybody that can be in their life and love them. And so those are all good things. And so I'm hopeful that y'all can make progress. And I do think it's important that that visitation gets set up as soon as possible. I know it's not going to be real easy since the kids are in different placements, but I think that's something that y'all can work with. And maybe after this hearing, y'all can get together with Ms. De La Rosa and try to schedule a visit within the next week. Okay. And if you all agree that someone else could supervise the visit, if all of you feel comfortable with that, which that would include Ms. Swallow as the children's attorney, if you all are comfortable that you can identify someone else who can do the visitation, can supervise visits, then I don't have any objection to changing that over from supervised by the department. I just want to say that now. I think it should start out being the department supervising, but I think that hopefully as y'all work together, that can change. As well, as long as the person, obviously the person doing the supervision would have to agree as well. Okay. So if you can think of somebody, Ms. De La Rosa, besides one of the fathers that might be able to help provide visitation, then, let your caseworker know that. Okay.
And Judge, if I may, can I request that the court authorize, just so everyone's aware, that the fathers and Ms. Aunt Kaylee Tilley, that they can work together to coordinate sibling contact. I think it's super important that these siblings continue to see each other, and that would include Bentley. That does not include the mom. It's just solely for the kids. And then Bentley's visitation is addressed in the temporary orders that were just entered into out of Kendall County, for which Ms. Holton represents the father on.
Okay. And by the way, Ms. Holden is just here to observe this proceeding. So, but okay, that sounds very reasonable, and I think it is important for siblings to be able to have visits. And as long as the kids are with relatives and family members, it should make it pretty easy to be able to facilitate those. And so I would hope that you all can work together. Maybe I don't know what rules you have, the department would have in terms of supervision, but if, maybe Bentley could go and visit, spend some time visiting where the twins are or something, for example. So I think that's hopefully something that y'all can work out on your own. I think it's important. The other thing I will say, it's really important to communicate with each other. And that goes to all the parties in this case, because everybody needs to be on the same page. And there's a lot of people involved in this case. That includes the relatives, the attorneys, and you all need to, if you make decisions about the siblings visits, I'm not saying you need to get permission for that, but you ought to, let people know, here's what we've got planned. Maybe share your schedule. Here's what the twins are doing this week. They're going to be, in daycare, or they're going to be, doing whatever, so that everybody is aware of what's going on. Because both the caseworker and Ms. Swallow, may drop in and visit the kids, anytime, and just to check on them and see how they're doing. So everybody needs to be aware of what's going on.
Judge, I had one more thing. I'm sorry.
That's okay.
The youngest, Charlie, she could benefit from daycare at this time, and that's something that the department can assist with. And I would request that the court order the department to assist placement with, or to assist Ms. Tilley with putting Charlie in daycare.
Do you work, Ms. Tilley? Placement, Tilley?
Can you hear me?
Yes, now I can.
Yes, ma'am. I work. I'm a caregiver for the elderly, and my schedule's from 7:45 to about noon. And then I can come home and do my schoolwork and everything online and be here with Charlie. But it would really help a daycare situation, especially with summertime coming. I'm going to have all my kids home, and I'm going to have to figure out something for 6 kids.
Well, the reason I ask about working is because I know I think there's some department regulation about getting daycare for people that are working full time or something. But I can't guarantee what they can come up with, but I will let's put in the order that the department will assist trying to implement daycare for the youngest child.
Thank you.
All right. Is there anything else we need to address at this time? All right. I hope you all will just take today as just the start of this, and you'll start, really focusing on dealing with, being involved in services and working together so that you all can become better parents and that we can resolve this case sooner rather than later. So I wish you all the best of luck. Okay. Next hearing, July 24th at 9:30.
Thank you, Judge.
Okay. If there's nothing further, you all may be
Your Honor, I
excused.
appreciate your patience. I do believe the parties have an agreement.
Okay. I appreciate y'all working together. It's worth it if we can get an agreement out of it, and we do need to get moving because we've been taking up quite a bit of time. But are y'all ready for me to go ahead and call the case?
Yes, Your Honor.
Okay, thank you. We are here by Zoom. This is a multi-county docket today that I'm hearing for Judge Falkenberg. So I'd like to start with announcements, and we'll start with Ms. Levy.
Leslie Levy, attorney for the department. State is ready.
Investigation Supervisor Jimmy Dresden Mitchell.
Ashley Peterman, Child Protective Investigations.
Irene Acosta, attorney ad litem, appointed to represent the respondent mother. She's present. I'm ready. Mrs. Slaughter, can you unmute and announce?
Can you hear me?
Yes.
Okay, yes, Ashley Slaughter, present.
Okay, Kurt Rudkin, attorney for respondent father Jonathan Slaughter. We are ready and he's present. Jonathan, could you announce that you're present? Oh, no.
I guess he's on mute still. I think you've done it. Go ahead and state your name, sir.
There you go. Maybe.
Well, let's keep going and we'll come back to Mr. Slaughter.
Kendra Sims, attorney ad litem for the children.
All right, thank you.
Amy Harding, Hill Country Casa supervisor, guardian ad litem for the children.
All right, Mr. Slaughter, can you try again and state your name, please? I think he must not be able to hear me. I don't know.
I don't know either. Because he and I were conversing, no problem, a few minutes ago in the breakout room.
Well, I guess let's just go on and we'll see where we go. If he gets in, we'll stop and talk to him for a minute.
Yes, this is me. Can you hear me?
Yes, go ahead. Just state your name, sir. Can you just say your name?
Hello. My name is Jonathan Slaughter.
Okay, since we have an announcement, it sounds like all parties are present. The court will also note that both parents have been properly served with notice of this proceeding. And I will ask Ms. Levy, since I know you all spent quite a bit of time conferring, to state whether you have reached an agreement and what the, the basic gist of your agreement is.
Thank you, Your Honor. The parties are in agreement to temporary managing conservatorship to the department. Visitation is agreed at 2 hours twice monthly. When the children, if the parents are not in inpatient treatment, if they do inpatient treatment, visitation will be whatever can be accommodated by the facility. We are authorizing the parents to have phone communication with the children. I believe at least one of them has their own phone. And unless there's any type of later issue with that contact, the department has no problem with that. And we are in agreement to do an expedited home study on the maternal grandparents, which is where the children are currently placed. Other than that, we will discuss services at an FGC. And I believe that's the full extent of the agreement.
Okay. Well, let me ask you on behalf of your client, Mr. Rudkin, is that under your understanding of what you all agreed to?
Yes, Your Honor.
And let's see, Ms. Acosta, is that your understanding as well?
Yes, Your Honor, it is.
And Ms. Sims?
Yes, Your Honor.
And Ms. Harding?
Yes, Your Honor, that is my agreement.
And let me ask you, and I'll ask Ms. Sims, do you feel that that agreement is in the best interest of the children?
Yes, Your Honor, I do.
I do as well, Your Honor.
Okay, thank you. And so the children are currently placed with the maternal grandparents. Is that correct?
Yes, ma'am.
Okay. Okay. But then at this time, the court will enter a temporary order. That's an agreed temporary order. The court will name the department as a temporary managing conservator of both children. The court will continue the placement of the children in the home of the maternal grandparents and will order an expedited home study on that home. I do think both parents need to attend inpatient treatment. I don't know if you agreed that that would be part of the services, but I do think that is appropriate. I will approve the visitation as stated forth by the department's attorney. I think that if you both get into inpatient treatment, I think that it's appropriate to facilitate as much phone contact or other contact as is appropriate for the children. Let's see. And I guess you'll probably discuss that a little more fully when you get to the FGC. But I would say that as to the parents, I would suggest that you go ahead and start pursuing that as an option and not wait till you get to the FGC. Mr. Slaughter, did you have a question?
Yes.
All right, go ahead. Go ahead, sir.
I can hear you. I can hear you.
Yeah, I can hear you, sir. What was your question? I think he's just still having some computer issues. Is there anything that anyone would like to add? I will advise both parents that the state of Texas gives parents 1 year in order to demonstrate that you can provide a safe and stable, drug-free, violence-free home for your children. If you're not able to do that, your rights are subject to being restricted or even terminated. So I want you both to understand that. And if drugs are an issue, it's going to be difficult for you to get your children returned to you unless you address that problem. That's why I recommend that you try to get into treatment just as soon as possible. We are going to be scheduled for what's called a status hearing on June 20th at 11:30. So you all need to schedule that family group conference prior to that date. And it's kind of a short turnaround. So hopefully you can get that scheduled and the parents can get started on the services as soon as possible. The sooner you get started with the services, the sooner we can proceed toward getting your children returned to you. Is there anything else I've forgotten or anything, other issues that need to be addressed at this time?
Your Honor, could we defer an indigency finding until the status hearing given the technical issues?
Yes, I think that's a good idea. And what I would say, if the parents have those affidavits of indigency, they need to be sure and fill out everything on those affidavits. Even if they don't have income, they need to put unemployed or zero or living with someone else or something so that we can make a determination about indigency. Any other issues from anybody? I'm glad you all were able to make an agreement today. Like I said, I think the sooner parents can get started with the services. Are there services being recommended for the children? Or are you going to be discussing that at the FGC as well, Ms. Levy?
I think that'll be discussed at the FGC.
Okay. All right. Anything else?
No, Your Honor.
Like I said, next hearing June 20th at 11:30.
Thank you.
If there's nothing further, thank you all and good luck to you. All parties may be excused. I asked Ms. Greenlee to stay on the phone for just a second.
With that, would you please begin the announcements?
Michelle Surratt, attorney for the department, present, ready to proceed. I'll allow Belong to introduce themselves.
Katarina Lewis, Belong Permanency Specialist. Ashley Crouch, Belong Permanency Supervisor.
Irene Acosta, attorney for the respondent mother.
David Nelson, Casa Guardian Ad Litem.
Amy Harding, Hill Country Casa Supervisor.
Kendra Sims, attorney ad litem for the children.
I don't know if I'm next. Jody Johnson, paternal grandmother.
Ms. Slaughter, can you unmute and announce, please?
Ambria Slaughter, I'm the aunt.
Thank you. All right, so we're missing both parents. There's Mr. Rudkin. Miss Lewis, did you have any contact with either parent before?
Mr. Slaughter is currently in inpatient, so I'm not sure if he's going to be getting on. I know he knew about it. I've spoken with Miss Slaughter, but I called her earlier and she did not answer me.
Your Honor, I'll reach out to her.
Thank you, Mr. Acosta. Mr. Rudkin, when you're ready, can you announce?
Sure. Kurt Rudkin for Father Jonathan Slaughter.
Okay.
We're here today for a status hearing. At this point, we do not have either parent present, but I did review Ms. Lewis's status report. Just going to go over the high points here. Children are placed with family or kinship in Travis County. Is that placement safe and appropriate, meeting their needs?
Yes, however, that is going to be changing by Monday. They're going to be placed with their paternal aunt and uncle in Allen, Texas.
What county is that?
I am unsure what county.
Collin County, Your Honor.
Yeah, it's Collin County.
Thank you. I apologize.
It's all right. And they're going to be placed there Monday,
That is our plan, yes.
24th.
Yes.
All right. There's no Indian child heritage in this case, is there?
No.
All right. At this time, is their current placement safe and appropriate, meeting their needs?
Yes, they are actually currently on a visit with their paternal grandmother and grandpa. But yes, it is.
But it's in their best interest to move with the aunt and uncle in Collin County.
Yes.
Is that the least restricted placement available?
Yes.
I noticed in the report that they've had, they need a medical and a dental checkup. Is that still the case?
They were able to get their medical completed on June 6th. And then they do need a dental, yes, and that is in the process of being scheduled, and the new placement is aware of that.
Are there any known dental concerns, anything that's going on right now that?
I don't believe so. I have not been notified of that.
Okay. Have they been evaluated? Let's see. Well, I guess they're too old. Have either of them had a CANS?
They have not had a CANS or a psychological yet. However, those are already scheduled, and are coming up next week.
Okay. Have you spoken to the future caregivers about school? Do we know where they're going to be going to school, and is that all set up?
Yes, we have talked about school. I'm not sure the exact school that they'll be going to, but I will get that information, and yes, they will be going to school there.
Okay. All right, and then like I said, we don't have either parent here, so have the parents been participating in their visitations?
Yes.
Okay. Now, how long has Mr. Slaughter been at rehab?
He has been in rehab about a week now.
And where is mom? Where's she living?
I don't have an address for her, but I believe she is in the Fredericksburg area.
Are the visitation, well, before dad went to rehab, were the visitations appropriate?
Yes, they were.
All right, she's here now. All right, and are you asking to continue the current visitation schedules?
Yes, I am. I do know the kids are going to be a little farther now, so I am asking that we all come together and be able to find a solution for at least once a month, maybe, or if the parents are able to get up there bi-weekly, I'm okay with that and keeping it the same.
And as long as father is an inpatient, is that virtual only, or have you been made aware of some sort of in-person visitation he could attend?
I have not been made aware of any in person, but I'm hopeful that we can get virtual set up so they can have virtual contact with him while he's there. He's in San Angelo, so that's pretty far from Dallas.
Yes, it's quite a drive. Okay. You were all able to hold a family group conference?
Yes.
And at that family group conference, did the parents participate?
Yes, they did.
The parents review and sign the family plans of service?
Yes. Miss Slaughter was able to sign it while she was there. Mr. Slaughter was virtual, so I have sent him a copy of it for him to review and sign.
Those family plans of service were filed?
Yes.
And do both parents have a copy of it?
Yes.
Are the services on the family plan of service narrowly tailored to address the concerns that brought the children into care?
Yes, they are.
You believe they're in the best interest of the children?
I do.
Can you briefly set forth the services that you're asking both parents to do?
Yes, I can. I am asking both parents to continue their visitation with their children. I'm asking them to engage in a psychological evaluation along with participating in individual counseling, random drug testing. I'm asking for Ms. Slaughter to complete her OZAR assessment tomorrow that is scheduled. Mr. Slaughter has already completed his drug and alcohol assessment and is now an inpatient. So we would just ask that after he's done with that to follow any recommendations for outpatient or anything like that as well.
Parents are cooperating with you?
Yes.
As of today, has either parent fully addressed the concerns that brought the children into care?
No.
As of today, is it safe to return the children to either parent?
No.
Are you asking that the children remain in the temporary management conservatorship of the department / belong?
Yes, I am.
Ms. Surratt, any questions for Ms. Lewis?
No, Your Honor.
Miss, before I go into your cross, Miss Acosta, Miss Slaughter, are you there? It says Ashley's iPhone. Can you hear me? Can you unmute, please? *6.
Can you hear me?
I can hear you now. Could you state
Okay.
your name for the record, please?
Ashley Slaughter?
Would you raise your right hand, please?
Yes.
Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, ma'am. I'm going to put you back on mute, and your attorney, Ms. Acosta, is going to ask some questions of Ms. Lewis, who is the permanency specialist for Belong, okay?
Okay.
All right. Go ahead, Ms. Acosta.
Thank you. Ms. Lewis, what services are you requesting of Ms. Slaughter?
Yes, I'm requesting her to complete her drug and alcohol assessment. I'm asking her to follow all recommendations from that, whether it be inpatient, outpatient, any of that. I'm also asking her to complete a psychological evaluation, engage in individual counseling, and random drug testing.
Okay, of those services, which referrals have been sent out?
And OZAR has been sent out, individual counseling has been sent out. Oh my goodness. A psychological evaluation has also been sent out. And then I will drug test her as well.
Okay, and does she have all of the information for the providers?
Yes, and she has communicated with them as well.
Okay, which services has she set up so far?
She was communicating with the individual counselor to get a session set up, so I'll follow up on that. And then tomorrow she actually has her OZAR at 10:30, I believe.
Okay, and has her psychological been scheduled?
I do not believe it's been scheduled, but I'll follow up with that referral and see.
Okay, and of those services, which is the most important?
I believe her OZAR drug and alcohol assessment. Those are our main concerns, is the drugs.
Okay, with regard to the visit, how far are the kids going to be from her now?
About 4.5 hours.
Okay. Given the distance, would it be possible with her with more compliance as she continues with her services to set up additional virtual visits in between her in-person visits to have increased contact with the kids?
Yes, I wouldn't be opposed to that.
Okay. Is there anything else that she needs to be doing right now?
Not at this time, just continue contact with me and we'll get her in her services.
Okay, thank you. I'll pass the witness, Judge.
Mr. Rookin?
How is Mr. Slaughter doing in his rehab so far? Do you have any progress reports from rehab?
I do not yet. I'm working on getting a counselor's information. However, I do know he called me yesterday and he sounded like he was doing well.
Good. And do you know when he'll be completed, if he does everything like he's supposed to do, the estimated completion date?
I do not yet, but I am thinking probably the end of July is probably sounds about right.
So has he done everything he's been asked to do so far in his family plan of service?
Yes.
Any criticisms or shortcomings you think you need to bring up right now?
Not at this time, no.
Okay. Pass witness.
Ms. Sims?
I don't have any questions, Your Honor.
Any redirect, Ms. Surratt?
No, Your Honor.
Any other witnesses or evidence?
No, Your Honor.
All right. Ms. Acosta, anything else?
No, Your Honor, nothing from me.
Mr. Rudkin, Ms. Sims, anything else?
No, Your Honor.
Okay. Let me hear your report, if you would, Ms. Sims, please.
Yes, Your Honor. So yesterday, Mr. Nelson and I got to FaceTime with the kids up in Dallas. They're with their paternal grandparents, and they have been kind of there for an extended visit. The kids both seemed like they were doing well. They were excited to be there. The grandparents put them in camps. Emma's going to art camp. Clayton's going to soccer camp. Next week, they're going to go to horse camp with their cousins. The grandparents report they've adjusted well. They're getting on a schedule. I don't have any concerns with that. I'm very happy that the aunt and uncle are going to take placement of the kids. This all kind of just happened. I haven't really gotten to visit with them, but I don't have any concerns. The grandparents are right there to help. So I'm very pleased right now with how everything's going.
Thank you, Ms. Sims. Mr. Nelson?
Like you said, we met with the kids yesterday. I was very pleased. They looked happy. Emma likes to swim and dive, apparently, and she likes Yahtzee, so be prepared for Yahtzee. Clayton, John enjoys playing soccer and seemed happy. They seemed happy where they were. And I'm very pleased with the placement with the aunt and uncle.
All right. Thank you. Okay, then for the purposes of the status hearing, court finds there's no Indian child heritage in this suit. Court finds that Mr. Slaughter at this point in time is attending inpatient and is not present today. The court will excuse that. Court finds that the placement of the children will be changing to Allen, Texas, and Collin County, effective June 24th, 2024. At this time, the current placement is safe and appropriate, meeting the needs of the children, but it's in their best interest, based on the testimony, to move to the aunt and uncle's home, so the court will order that be done. Court finds that the current placement is the least restricted placement available, and that by the testimony and reports, the placement with the aunt and uncle will also be least restrictive. Court finds that the children are up to date on their medical, but they need a dental. I'm going to order the long follow-up with the placement, make sure we get that scheduled. Court makes a finding that the parties have already scheduled the children for cans and psychologicals. Court finds that their educational needs are being addressed. And I'm going to continue the current visitation schedules, but authorize the parties as appropriate based on engagement of the parents and the ability to do so, to start increasing, whether it be virtually or in person, as the parties agree. If you can't agree, then we'll come back into court and we'll talk about it, or we can have a conference call, whatever it takes to get that done. Court finds the parties held a family group conference. The parents participated. The parents participated in the creation of the plan. Mom has reviewed her plan and signed it. Dad is still reviewing. Court finds that both parents have a copy of their family plan of service. Court finds the plans are narrowly tailored to address the concerns that brought the children into care, and that it's in the best interest of the children to make those family plans of service orders of the court. Court finds that the parents are cooperating with Belong. As of today, it's not safe to return the children to either parent, and as of today, neither parent has fully addressed the concerns that brought the children into care. Court will turn the family plans of service that are on file with the court into orders. Our next hearing will be September 24th, 2024 at 11. September 24th, 2024 at 11. Now, I know he's not here to hear it, but obviously you can share this information with him, Mr. Rudkin, but you are Ms. Slaughter. So I want to make sure you understand the state of Texas gives parents in CPS cases 12 months to demonstrate that you can provide a safe, stable, violence, and drug-free home for your child. In the event you cannot do so, your rights to your child are subject to further restriction as they are now, or termination. Everything is set and in place right now, Ms. Slaughter, for you to be reunified with your child, but you have to do the work. You can't just check the boxes off the list. You have to engage in these services and make sure that you address these concerns and that you use what you learn to improve your child's lives and your parenting experience and to reunify your family. The clock is ticking. It will run out. You cannot put this stuff off, and you can't delay it, and you can't look at it like, oh, I'll do that next week. You've got to remember that your children are young. They're 6 and 12. So a month of their life is a lot longer than a month of yours. Okay? Things are going to move fast. So adjust with it and make sure that you stay in touch with Ms. Lewis and your attorney. And I think that's everything. Ms. Surratt, is there anything I failed to address?
No, Your Honor.
Okay. Thank you all for your time and your service. Thank you to the family for doing what you're doing. And if nothing further, I'll see you September 24th at 11 a.m. All parties are excused.
Thank you.
Thank you.
You're welcome.
Thank you, Your Honor.